And that is what you said?
Yes, sir, that is what I said at that point in time.
Help? It was important for you to let Mr. Bryan know that he was a witness in this matter.
It was important for him to know that I appreciated him calling me back like he said he would after my initial contact with him. It was important that he know what his role was at this point in time. And I wanted him to understand that I was looking at this objectively from a fresh set of eyes and not going strictly off what Glenn County Police Department had relayed.
Now, when you told him that you had reviewed the previous statements to the Glenn County Police Department and the other evidence in the case, you weren't lying to him, were you?
I was not.
You did actually. You had all that information available to you.
Yes, sir.
And you know that the Glenn County Police Department had referred to him as a witness.
I don't recall that specifically, but if it's in there, it's in there.
Okay. Well, you reviewed their case file.
I did, in pieces, I would say.
And when you became involved in this case, the Glenn County Police Department listed him as a witness.
Asked and answered.
I don't think so, but I'll defer to the court.
Yeah, I think, yeah, go ahead. If you know, go ahead.
The Glenn County Police Department had identified him as a witness in this matter.
I don't recall.
Okay, fair enough. But you told him that he was a witness,
I told him at that point in time.
which would be consistent, as far as you know, with everything he had been led to believe.
Objection to speculation as far as what Mr. Bryan was led to believe.
I'll move on. You had Mr. Bryan execute a consent form, I believe.
It's in evidence. It should be up there.
Now, Coach Winshaw.
Yes.
I'm showing you what's been marked State's Exhibit 197.
Thank you.
I believe you read that to the jury earlier.
Yes, sir, I did.
Where in there does it tell Mr. Bryan what he's under investigation for?
It doesn't.
Okay. Thank you, sir.
I would add, though, that he knew what the investigation was about, being as the whole case was around Ahmaud Arbery and his death.
Well, we'll come back to that. Maybe I slept through it earlier, but where was the Miranda form that you used on this occasion?
He was not under arrest. Miranda is only required when somebody's being questioned while they're in custody. At no time was Mr. Bryan in custody during these questioning. As a matter of fact, he was advised from the beginning that he was free to leave and that he was free to stop talking at any time, to which Mr. Goff was present during those conversations.
Well, let's be clear. You were under no legal obligation to give Mr. Bryan Miranda rights, but you could have.
There was no reason to.
But you could have.
I could do a lot of things, but there's no reason to read him Miranda if he is not in custody, or there's no chance of him being put into custody at that time.
You've never Mirandized somebody who wasn't in custody?
I do a lot of different things depending on an investigation. The statutes and case law gives us parameters for which we have to work through. What I do in one case may be different than another based on the circumstances of that case. There's no straight cookie cutter approach to this. The point is to always get the information that's needed in the investigations so that you can make a reasonable decision on charges should they be made or not.
But in this case, there was a specific reason why you did not Mirandize Mr. Bryan.
That's correct, because he was not in custody.
When you fill out a Miranda form, are you not required to tell the subject what you're investigating them for?
No, sir.
No? You don't do that.
Objection to relevance of a Miranda form, Judge, when we've already established that a Miranda form was not given in this case.
with all respect, the credibility of all witnesses is a matter for the jury, even police
It's
officers.
sustained, he sort of said he didn't Mirandize.
All right. You never used the terms citizen arrest in this conversation, any of these interviews.
Neither myself or Mr. Bryan discussed citizen arrest, no, sir.
Okay. You discussed other legal concepts, did you not?
Which ones?
Such as self-defense.
I don't recall that specifically. Do you have a reference?
No, you don't recall that at all.
If you have a reference to refresh my memory, but I don't recall that specifically.
Well, we'll circle back to that. You did discuss whether Mr. Bryan was scared on the side of the road.
Again, do you have a specific reference?
Did you discuss whether Mr. Bryan took defensive action to pull away from Mr. Arbery when he felt Mr. Arbery was trying to get in his truck? Did you not testify to that earlier today?
Not in relation to self-defense, but in relation to the series of events that occurred prior to Mr. Arbery's death, then yes, we discussed that.
All right. Now, shortly into the interview, concern became apparent as to what your intentions were, did it not?
Concern for who?
There was concern on the part of Mr. Bryan as to what your intentions were.
Objection to speculation about the concern of Mr. Bryan.
Oh, we don't have to speculate, Your Honor.
Just rephrase.
Directing your attention to page 21 of the transcript,
Which transcript?
the 511 transcript. 18 pages. After this colloquy on page 3. Did you get a chance to review page 21?
Is there a certain area that you want me to, that you're
Yeah.
referencing?
Tell us about the part where the interview stops. Matter of fact, you just got, I don't have line numbers on my copy.
Okay.
But from the part where it says, okay, I'll step outside a minute.
Okay. In the beginning, I guess to give some context, in the beginning of this interview, Mr. Goff had even reminded Mr. Bryan, while I was telling him about the voluntariness of the interview, Mr. Goff reminded him that at any point we could pause the interview so that Mr. Bryan could confer with his attorney on any questions he may have, and that's, I think, what is occurring right here. Mr. Bryan starts off on this page stating, he asked me, and I don't exactly remember right now what exactly he said, other than he was just saying that.
Objection, Judge, may we approach?
That wasn't me.
Well, you directed him to it.
No, I directed him to the break in the conversation.
May we approach, Your Honor?